So I'd like to welcome Doug Desmarais from Smith and Downey. Take it away, Doug.
Glad to be able to spend a few minutes talking about the labor and employment side of this awful COVID-19 epidemic. All of us can't wait for this to be some ancient story that we look back and think how we navigated it effortlessly, but it doesn't certainly feel effortless when you're in the midst of it. Um, we're going to be talking about the primary COVID-19 law that governs all workplaces. But before I get there, I'm going to talk about without scrolling down to some of the later slides because I don't think we'd have a natural amount of time to get to them. To remind everybody that even though there are these COVID-19 specific statutes that are out there, they are in addition to all the other laws that have been there all along. And so, as we zero in and focus on this new development, let's not forget that had there been no Families First Coronavirus Response Act, there would still be lots of laws that still would provide employee rights with respect to a pandemic. Because this is not the first major health event that's happened. We've had other major flu events that have taken place, but this is the first pandemic that has shut down a society in more than 100 years. But things like the Maryland Healthy Working Family Act that provides paid sick and safe leave. All employers should have MHW, Maryland Healthy Working Family Act policies in their handbooks and be prepared to provide sick and safe leave. There's the Flexible Leave Act in Maryland, which provides employees rights to access any available paid leave to care for immediate family members who have medical issues. There is the Family Medical Leave Act, which provides unpaid leave to employers with 50 or more employees. There is the American with Disabilities Act, which requires employers to seek to accommodate the disabilities of employees, that imposes very strict confidentiality obligations. The hallmark of that law is the interactive dialogue that takes place as part of the reasonable accommodation process. That law is still in place, and all the other ones I just mentioned, they're still operative. And we have to not only comply with the new law, we have to balance them with the existing law. And then behind all the things that I've just spoken about are discrimination laws. And, I sometimes get the question, if somebody who owns an antique shop calls me up and says one of my employees just threw an 18th century vase against the wall and broke it, can I fire that person? And the answer is, well, it depends. Have you ever had any other employees throw vases against the wall? And the answer might be, well, 19th century vases, but not 18th century vases. Well, I'd want to know what they did with that employee. And if they gave that employee a pass, and they don't want to give the current employee a pass, I'd want to know a whole lot about them: their race, color, religion, national origin, sex, gender identity, expression, sexual orientation, veteran status, et cetera, et cetera. So as you think through these issues, do not forget that there are a host of laws that are out there that we have to be concerned about. And with that transition, let's talk about the Families First Coronavirus Response Act, otherwise known as the FFCRA. We got an acronym for everything in my business, and that's the newest one. It became effective on April the 1st, and there was a non-enforcement period that ended last Friday. And so any shortcomings that took place in good faith through last Friday, you have a fair amount of forgiveness that awaits you. Any shortcomings that are taking place this week and beyond, not so much. There can be repercussions for not complying if you get to that point. It provides paid sick leave for COVID-19 reasons. The hallmark are the expansion of the Family and Medical Leave Act, which now includes paid family medical leave, something that has never been part of traditional FMLA coverage, has a payroll tax credit included to help fund the paid leave mandates. And that's a big deal. Employers in the short term have to write the check, but then they can, in very short order, get tax credits that effectively will pass the payment on to the government. It's noteworthy that since it's ultimately the government that's going to be paying for this, they are a lot less forgiving than one normally would expect from the government when it comes to overpayment to employees. They want to make sure that these employees of yours are precisely eligible. And if they're not, if there's a gray area, then they're not going to pay for it. Normally under something like the American with Disabilities Act, they'd say, well, if it's a gray area, we want you to err on the side of protecting the employee. Now that they're writing the check, they're saying if it's a gray area, you lose. You pay for the leave of absence. Okay. There's going to be help with unemployment, help for state unemployment insurance. And then there are two divisions, which we'll be talking about next. Division C is the Emergency Family Medical Leave Expansion Act, and Division E is the Emergency Paid Sick Leave Act. This applies to employers with fewer than 500 employees. And you determine the number of employees at the time that the employee is having a FFCRA event. So it's possible that 1 week you might have more than 500 employees and not be obligated to provide either form of paid leave. And then you might have a layoff, and then you might be below that. And you look at that snapshot moment when the employee leaves the need of absence. Next is Division C, FMLA expansion. This again applies to employers with fewer than 500 employees. They're eligible if they have been on the payroll for 30 calendar days immediately prior to the day leave would begin. You contrast that with traditional family medical leave. You had to have been with the employer for a year and worked 1,250 hours in the preceding 12 months. You had to have 49 other employees within a 75-mile radius. And so there are provisions that are very familiar to practitioners as it relates to the traditional Family Medical Leave Act that are thrown out the window for purposes of this expanded family medical leave. And what it does, it provides an additional use for the family medical leave. It doesn't add 12 weeks over and above the traditional 12 weeks, but it allows you to, in addition to the standard family medical leave forms of leave, to take paid FMLA leave where the employee is unable to work or telework due to the need for leave to care for a minor child, initially thought to be younger than 18 years of age, but it also might include a child who's over 18, but who is incapable of self-care because the child's school or place of care has been closed due to a COVID-19 reason. And this is something that's also, by the way, going to be one of the reasons that an employee can take emergency paid sick leave as well. And that'll be a little further down the presentation. So the first 10 work days, in other words, the first 2 traditional work weeks, are unpaid leave. And the employee is able to substitute any accrued vacation leave, personal leave, or medical sick leave for this unpaid leave. And the employee may use the unused EPSL, emergency paid sick leave time as well. After the first 10 days, the leave must be paid in an amount equal to 2/3 of the employee's regular rate of pay, up to $200 a day. So the most that's going to come out of the employer's pocket and the most that the government will tax credit you for those payments is $200 a day or $10,000 in the aggregate. If you wish to pay more than that for an employee, you may, but you're not going to get the tax credit for the excess over the $200 a day or over the $10,000. The employee is only entitled to a total of 12 weeks of leave due to caring for a child whose school or place of care has closed because of COVID-19. Now, if the employee has already used family medical leave for other reasons in the preceding 12 months, assuming that the employer is using a rolling backward method, which is the preferred and most common method, then the only available family medical leave plus is going to be the delta between 12 minus the number of weeks that have been taken previously. School leave essentials. Employees may take FFCRA child care leave to care for a child only when she is actually caring for the child, if she's unable to work or telework as a result of providing care. Now, if the employee is unable to work because the employee's been laid off, well, then that's not an FFCRA event. But if the employee does have work to do, but can't telework because they're providing care for small children, and I'm the father of 5, and so I kind of know what that's like, then that employee could be eligible for expanded family medical leave. Generally, the employee does not need to take such leave if a co-parent, co-guardian, or the child's usual care provider is available to provide the child care needs. I did get a call just last night about a workplace where an employee said she does have a husband who normally could watch the child, but he's teleworking, and his telework has been deemed to be the priority household. And under that scenario, they can decide who the primary caretaker is going to be of the child when you have those kinds of competing interests in a household. With respect to the interaction of FMLA expansion with the regular family, I think we've discussed that there are coverage opportunities available for expanded family medical leave that are not available for broader family medical leave. And we've talked about how one is paid and one is not paid. And if someone has already used up all their traditional family medical leave, then they're out of luck when it comes to paid expanded family medical leave. Now, the next category is the emergency paid sick leave, or EPSL. Also applies to employers with fewer than 500 employees. And it provides 10 days of paid leave, a total of 80 hours for full-time employees, and it can be used for 6 COVID-19 related reasons. And we're going to talk about that in a moment. The Department of Labor has issued some pretty comprehensive regulations, over 120 pages, and it's rather remarkable feat to turn around something that comprehensive in such a short order. As Adam pointed out, back in early March, people were talking about March Madness, and everyone thought that was going to happen, and it didn't. And here we are, still not at the last week, or we're just beginning the last week of April. And to have an agency turn around 120 pages of very comprehensive regulations is something that is entirely unheard of, something that has not happened before. And so kudos to the hardworking folks at the Department of Labor for being so responsive. So emergency.
Doug, I'll note that on the benefit side, the Department of Labor has been conspicuously quiet, and so I think the thought process is that they have all hands on deck over on your side of the house, because we really haven't gotten that much from them. So it's again, kudos to them for that. Their silence on our side is notable, but perhaps understandable given how important the things you are that you're talking about.
Well, I also think it's the allure of sex, drugs, and rock and roll with respect to the labor and employment work. So it could be a combination of the two. But they have been responsive, and they've answered a lot of questions. You have to kind of dig through the weeds a little bit to find some of those answers. Surprisingly, some of the answers actually run contrary to the precise language of the statute. My guess is that although courts would normally not be receptive to an agency trying to write law, which is not their task, their task is to help support the enforcement of the law. My guess is they're going to get a free pass because these are such unusual circumstances. Let's talk about the 6 reasons that you can take emergency paid sick leave. It's really 5 reasons. That 6th reason is one that is really a placeholder in case the Department of Labor ever wants to fill it in. They've not yet filled it in. But there are really 2 categories. There's categories 1, 2, and 3, and then there's category 4 and 5. 1 is the employee is subject to a federal, state, or local quarantine. And that's an individualized quarantine. There's some question as to whether a stay-at-home order is something that constitutes this level of quarantine. And what the Department of Labor has said is, well, yes, it is. But then they said, but it only applies to a quarantine that affects an individual and not anything that affects that individual's business. Meaning, if the reason that the employee is in need of the leave is because the business has been shut down because it's not essential, they said that doesn't count. And so one is hard pressed to find a factual scenario where a stay-at-home order would constitute the kind of quarantine that's envisioned in the EPSL. Next is the healthcare provider has advised the employee to self-quarantine. That may be because the employee has tested positive, and of course, if the employee has tested positive, that means they're very, very contagious and they're a threat to the health and perhaps the life of other people, and they will be ordered to self-quarantine. If you are aware of the fact that you have an infected employee, you have an obligation under OSHA, occupational safety and health laws, to make sure that you protect your employees from that individual. And something called the general duty clause under OSHA says that if you're aware of a condition that would pose a serious risk to someone's health or life, you've got to protect employees from that. And so if you have that situation, you need to protect your employees. But you ordering someone home does not trigger the EPSL. It's only when a healthcare provider has advised the employee to self-quarantine. And then the employee has symptoms is seeking diagnosis. If an employee calls up and says, I've got chills, a fever, and I'm coughing, it unfortunately sounds a lot like a COVID-19 infection. And if they're going to go see a healthcare provider, either in person or over the internet or over the telephone, that time could be a paid sick leave event. And it's paid at a higher rate, which we'll talk about in the next slide. The second category is the employee is caring for an individual under quarantine. Now, that care could be for a parent, it could be for a child, it could be for a spouse. It also could be for the vulnerable person who lives next door. You know, if you have somebody who is elderly and you bring over meals to them from time to time because they don't have anybody else in their life, or they're just in need, and you have traditionally assumed that kind of care role, which of course is beautiful and commendable if that's what the employee is doing, then that would constitute one of these triggering events for caring for an individual who's under quarantine, if in fact that neighbor is under quarantine. And lastly is something that's going to sound familiar because it's also the trigger for expanded family medical leave. And that's where the employee is caring for a child whose school or place of care is closed, or a child care provider is unavailable due to COVID-19. That's for a son and daughter, by the way. That's not the same thing as caring for the neighborhood kids. That's for one's own child in order to get paid sick leave. It must be available for immediate use. The Act prohibits an employer from requiring the employee to draw from existing paid time off. The employee must be allowed to use EPSL before dipping into any other accrued leave provided by the employer. You consider it a new leave bank. It's in addition to anything else that you've already offered. Now, there's a notice and records requirement. Hopefully, everybody who's in the sound of my voice has gone to the DOL website, printed out the PDF copy of the notice that has been provided by the Department of Labor, has taped it next to wherever you have other posters in your workplace. If you have employees who are not going to be seeing your workplace because they're teleworking, then the expectation is that you'll take that PDF copy and you'll attach it to an email and you'll send it to the employee and ask them to read it. And that's how you'll fulfill your posting requirements. How much do you get for emergency paid sick leave? For reasons 1, 2, and 3. And by way of reminder, 1, 2, and 3 means that the employee herself is having the COVID-19 event. She's been quarantined. She's been told by a healthcare provider to self-quarantine. She has symptoms and is seeking help. That is a higher rate, up to $511 a day, or potentially in the aggregate of $5,110. If, however, it's for reason 4, or maybe 6, but again, 6 doesn't exist right now, then it's 2/3 their regular rate, up to $200 a day, or $2,000 in the aggregate. And then for reason 5, which is to care for a child, it's the same thing as the expanded family medical leave, which is 2/3 of the employee's normal rate, up to $200 a day, and up to $12,000 in the aggregate. Now, the reason we're saying $12,000, it's $2,000 for EPSL, and then it's $10,000 for the expanded family medical leave. And we've talked about this substantially similar condition. That's reason number 6, and that doesn't exist quite yet. The enforcement period is happening now. It's advisable to have an FFCRA policy. It's not explicitly mandated in the same degree that employers are mandated if they have more than 50 employees. to have a Family Medical Leave Act policy that at the very least tracks all the information that's in the DOL poster, but it's advisable to have an FFCRA policy. It's going to expire on 12/31/2020, but because what's taking place is so pervasive in every workplace and throughout society, and because these rights are so important and have had so much money thrown underneath them and around them, it's highly advisable to have an FFCRA policy. It's highly advisable to put together application forms for employees who are seeking either emergency paid sick leave or expanded family medical leave. We don't have the privilege right now of those beautiful forms that the Department of Labor has put together for traditional family medical leave, but certainly the theme of those existing documents can be used to craft one's own request forms, and we strongly recommend that you have that. One of the reasons you want to have those request forms completed and preserved for up to 4 years is that if you're audited and there's a question as to whether or not you have allocated FFCRA properly and whether you therefore are entitled to the tax credit, you want to show that you were serious about this, that you recognize that the FFCRA was there, and that you took active, conscious, aggressive steps to be in full compliance. You do that by having forms in place and a policy in place, and being vigilant and making sure that employees are completing those forms. And there, if you are audited, you'll have easy access to a file, and it will be a very easy task for you, and it will be a quick review for the Department of Labor, and they'll move on to the next business and see whether they were the ones who were not in compliance, but it's not going to be you. This is again these posters and policies that we've just talked about. Next slide talks about how do you go about requesting FFCRA school leave. The employee should identify the following: the name and age of the child or children needing care, the name of the school or place of care, representation that no other person will be caring for the child, and if the child is older than 14, a statement describing special circumstances making it necessary to be absent to care for the child. And the Department of Labor has made it pretty clear that special circumstances, it better be pretty special, as opposed to, my kid never listens to me and all they want to do is play video games all day. Well, the Department of Labor has determined that most of us who have children have left our 15 and 16 and 17-year-olds by themselves. And if it was good enough to do that, to go out on a date with our significant other, it's certainly good enough to leave them alone during the day so that the employee can go about doing her or his work. Next slide is downsizing issues. We have a lot of questions from larger employers in particular right now about reducing wages and reducing hourly rate, reductions in salary. In order to reduce wages in the state of Maryland, you have to give one pay period advance notice. If you fail to give one pay period's advance notice, that means the week that you were in violation is subject to triple damages for the amount that was improperly withheld from the employee. So make sure that you give that one pay period's advance notice. It should be in writing. If you're going to reduce an hourly rate because you're trying to save money, again, make sure you give that full pay period's notice. Make sure that the reduction does not take you below the minimum wage requirements of whatever jurisdiction you are in. If you want to reduce a salary, that gets a little more complicated because under the Fair Labor Standards Act, there's something called the salary basis test. One, you want to make sure that the reduction doesn't take them below the salary basis test, which is just under $36,000. That's number one. Number two, Department of Labor doesn't like it when you play around with an exempt employee salary. The idea is that there's this predetermined amount that's always going to be available for them in weeks in which they performed work. And they don't want you gaming the system by saying we'll make you hourly when you're working 20 hours a week, but make you salaried when you're working 60 hours a week. In this case, you're not motivated by those kinds of sleight of hand approach, but instead, you're going to an employee and saying, we know we've always paid you $90,000 a year. Unfortunately, because of COVID-19 and the uncertainty of our industry, we've got to pay you $50,000 a year. It's going to be effective the pay period after next. you give that kind of notice and you make it clear that it's an indefinite reduction, then you should be fine with your salary basis test compliance, which of course is so integral to preserving the exempt status of the employee. The WARN Act has to do with what's called a plant closure or a mass layoff. And those events could require you to give notice, and that notice requirement is something that needs to be strictly complied with. This is for larger employers, and if anyone within the sound of my voice has any concerns that they've walked upon a WARN Act obligation, they should seek the help of experienced counsel and get some guidance. And then we'll end where we began. Keep in mind that the Maryland Healthy Working Family Act provides paid sick and safe leave for medical injury, illness, and conditions. And that injury, illness, and condition is much broader than what we've talked about for the FFCRA. It's for a much broader group of people. It's not just for the employee and the employee's spouse. It's to care for the employee's own mental or physical illness, injury, or condition, or a family member's physical illness, injury, or condition, to obtain preventive medical care for themselves or their family members. And if you look at the next slide, the family member is so broadly defined: spouse, child, parent, grandparent, grandchild, sibling, and then within each of those categories are many subcategories. And that Maryland Healthy Working Family Act compliance is very, very important. The employees are really not required to give much by way of notice. It's as soon as practicable for unforeseeable events. Sometimes it's not practicable to give notice until many hours after the start of a shift. And under the Maryland Healthy Working Family Act, employees have that kind of flexibility. We've talked about the Maryland Flexible Leave Act, and that's for a smaller category of family members, but very, very important. And then keep in mind that the Family Medical Leave Act, for those of you with 50 or more employees, is still out there. And then the American with Disabilities Act, we could talk for days about how that law impacts your workplace and how important it is for you to be in compliance. But that in a nutshell, and ADA accommodations, by the way, might include the allocation of unpaid sick leave for an employee if it doesn't cause the employer an undue hardship. But there you have it, in a half an hour or less, a snapshot of what's happening with COVID-19 issues. Glad to be able to spend some time talking about these important concepts and how wonderful it is to work with an organization that's so committed to their clients to make sure that everyone has appropriate information. So thank you very much.